for choosing this Virginia CLE seminar. Please note that it is licensed only to the original purchaser. It is protected by copyright law and may not be used by others to obtain MCLE credit. The codes it contains may not be disclosed to others. Audio codes are embedded randomly throughout this program to meet the requirements of the Mandatory Continuing Legal Education Board. Please listen carefully for those codes and write them down when you hear them announced. In order to obtain your MCLE Certification of Attendance form, you will have to enter those codes in the order in which they occur.
The next session is a judges panel, as you can see. And Pete Buckbauer is going to moderate this session. Leaving nothing to chance, Pete sent me the following email. Frank, out of concern that you might screw up my introduction, I've taken the liberty of drafting it for you. Read it as written and do not ad-lib. So here goes. Pete Buckbauer is by far and away the best family lawyer in Winchester, Virginia. His legal ability is surpassed only by his boyish good looks, and he is a scratch handicap golfer. I can't do it. Sorry. Pete Buckbauer formed Buckbauer McGuire in 1995. He is a past chair of the Family Law Section's Board of Governors and is currently a member of the Virginia Family Law Coalition. He is a fellow in the American Academy of Matrimonial Lawyers. And he recently helped establish the Collaborative Professionals of Northern Shenandoah Valley. Pete is another one of those guys who, whenever you ask, he seems to have time to say yes. This morning is another example. Please help me welcome Pete Buckbauer from Winchester.
Everything he said before the started Buckbauer McGuire is not true. Anyway. It's my pleasure to moderate the judges panel to discuss various issues you might have regarding recent developments, and particularly in light of this morning's presentation dealing with children as pawns in custody litigation. Today we're joined by Judge McCahill, Judge Rockwell, and Judge Blow, and it's my good fortune that they sat in the exact correct order that my introduction went. Judge McCahill received his BA from the College of William & Mary in 1973. He's a 1976 graduate of the University of Richmond Law School. He had an active family law practice in Leesburg from 76 to 98. During that time, he was admitted to fellowship in the American Academy of Matrimonial Lawyers. In 1998, he became a judge of the Loudoun County JDR Court, where he served until 2000 when he became a judge in the Circuit Court in Loudoun County. The Honorable Frederick Rockwell received his undergraduate degree from Randolph-Macon College. He's a 1979 graduate of the law school at the University of Richmond. He had an active private practice with soon to retire, I understand, Circuit Court Judge Mike Allen until 1994 when he became a judge with the Chesterfield County JDR Court. In 2002, Judge Rockwell again joined up with Judge Allen as he became a circuit court judge for Chesterfield County. Judge Rockwell is reputed to hold the unofficial state record for the fastest time between chambers and the bench, which he travels on a Segway. He is a member of the Board of Governors of the Family Law Section of the State Bar. Judge Randall Blow received his BS from the College of William & Mary in 1976, and he's a 1982 graduate of the George Mason University School of Law. After 19 years working in the Virginia Beach office of the city attorney, he was selected to serve as a judge of the Juvenile Domestic Relations District Court for Virginia Beach in 2001. He currently serves as the court's chief judge, and I understand he holds a distinction of creating a trend, maybe throughout the state, of flip-flop Fridays, where clerks are allowed to wear flip-flops, but I guess that only works at the beach. So, thank you very much for your participation today. Thank you for your questions that you handed up to me. I do have some that I'm going to perhaps not say exactly the way you gave them to me, but I'm going to try to handle them sort of in topical fashion. So first, judges, how do you handle CPS determinations? We heard from Rich before. Sometimes the report just comes in and the alleged offender is given an opportunity to explain themselves. He's qualified DSS workers as experts. Sometimes he says live testimony, give a foundation, but the report comes in. And then yet other times I've had judges insist that they're not going to consider the report. They'll consider all the evidence and make their own determination. So can you shed some light on what you think is the best practice, how you handle those questions?
I think what you just said is what I do. I think it's a distraction.
Get as close.
I'm sorry, it's a distraction. I'm not used to being a rock star, I'm sorry. I think it's a distraction. I think I should hear the evidence presented in the custody case. The abuse and neglect are found in the complaint, I think, is a distraction. Also, it doesn't come in, it's hearsay. I don't let it come in. I haven't.
Okay, so you don't view the conclusion itself as a fact that can be introduced, rather you insist that you'll make the decision yourself.
How does it get introduced? That's my question to you. How does it get introduced? It's usually the one parent or the other saying, I got a founded complaint against that bozo. And that's about it. I don't get a social worker. I don't have a report. I don't have anything like that. That's usually what I have. But I just think that's a distraction. I need to make my decision based on the evidence that is presented in court.
Okay, other judges?
I don't see it that often, but in the cases I've had it, I deal with it the same way. I think it's hearsay, obviously, and if there's a hearsay objection, then of course it's typically sustained. And then the next issue is if the attorneys are prepared to bring in the people, I think they can present the underlying facts, and then there will be a debate regarding the quality of the individual who is giving the opinion as to whether or not they're able to give an opinion, because that's really what it is. It's a conclusion that someone else has reached. It's a opinion, it's a conclusion. And then you can test the admissibility as to whether or not there's a proper foundation for the admission of it as an expert opinion. Otherwise, the court can listen to the facts and draw its own conclusion. It is a civil case, which means that, the ultimate issues can be discussed in a civil manner, but nevertheless, I look upon it as a conclusion or opinion. And many of the individuals that give those may not meet the gatekeeping requirements for expert testimony, in my view, but it just depends.
Yeah, I'm at the district court level, and I guess we sort of are a little bit more flexible with the rules of evidence. I shouldn't say that on the record, but it's a fact.
That was our experience.
Yes. I tend to allow them, but I do like to have a proper foundation laid. As far as once it comes in, I don't find it to be obviously dispositive. I look at it, in the weight of all the evidence, and try to make a determination as of everything I hear, all the evidence that comes in, all the testimony, all the exhibits. So it certainly isn't dispositive at all, but I do need to see a proper foundation laid. I won't just allow a party to bring a copy of it in and hand it to me and say, look at this. I need somebody to back it up and make sure that it's been properly vetted.
What role, if any, do you find of unfounded DSS investigations, determinations, in trying to assess a parent's particular fitness in a custody determination?
How do you mean that?
Well, if somebody keeps on getting complaints and they keep being determined to be unfounded, does that have any weight? Does it play at all in your decision, or is it basically irrelevant from your perspective?
I'd be interested to know who's making the complaint.
If you find out it's the other parent.
Then it's pertinent for that other parent, my consideration of the other parent. And I think there's a recent case to that point, too, where a person is being persistent and they're complaining about the husband, and it all turns out to be unfounded, and the court considered that. Not necessarily being dispositive, but I think if a parent keeps filing a complaint and it keeps being unfounded, that one of the factors is ability to promote a relationship, and I don't see that as promoting a relationship.
That presents an interesting twist on the issue of the admissibility of the opinion, because there again, there's that opinion that is unfounded versus founded. So that you'll typically find, in my view, in that situation, is the person who was the recipient of the complaint, where it's unfounded, now wants to use that as a weapon to suggest that the other side is purposely filing frivolous complaints. And so the person who's filing frivolous complaints may have to be a little bit more attuned to know that, okay, there may be a basis to keep that opinion out, because they're going to be the recipient of some blowback about how they are filing complaints, A, if you can get that into evidence that they're the ones doing it, and B, that it's unfounded, because there again, it's an opinion.
My experience has been pretty much the same as Judge Rockwell's. If I see numerous unfounded complaints over and over again, it normally shows that the other parent's being vindictive. That seems to be the case in most situations. Very seldom does it operate against the person whom the complaint is made. So I agree with you.
Take it one step back, and instead of it being the other parent, it's members of that parent's family. Is there vicarious liability?
And in my view, it depends whether or not they're part of what I call the posse. You know, the ones that are that surround the parent, and because sometimes people let other people do their dirty work, and there again, you have to plumb the depths there a little bit and find out what's really going on.
At times we find that just the allegation of abuse or neglect in a case can trigger at least temporary orders which interrupt the relationship between a parent and a child, maybe requiring supervision or a reduced amount of time between the child and the allegedly abusive parent. What do you do? What's your way or your radar, perhaps, in trying to call out not overreacting to an allegation, but at the same time protecting the child in a custody case?
One thing we've been seeing on a pretty regular basis here in the last couple of years in Virginia Beach, and I've been on the bench for 11 years, and I'd say for the first 9 years, I probably didn't have more than one or two of the cases I'm about to describe. But in the last couple of years, they seem to be coming in on a regular basis, and that is parents bypassing CPS and filing petitions for preliminary protective orders for the children against the other parent. And, you know, intake is not allowed to screen those things because the intake officers are not legally trained. They have to accept whatever comes across their desk. And so those cases come before us. What I normally do in a situation like that is we are fortunate to have a DSS liaison, a person who actually stays in the court the entire time the court's in session, and we can call upon them to investigate things sometimes within a couple of minutes, or maybe 15 minutes. They can make phone calls to see whether or not a complaint was actually filed and not taken, or if the person never contacted CPS in the first place. If the allegations in the affidavit seem to be serious enough, sometimes we ourselves will ask CPS to investigate it, and we will continue the case, not take any action, certainly not enter any ex parte orders, but ask the DSS liaison to coordinate with CPS, get the parent in touch with them, screen the case, see if they'll take it or not, and then we go from there. Other times, for whatever reason, the parent may not have contacted CPS, but yet it is a serious complaint. And if it's very serious and it seems to have some level of credibility, at least at the initial hearing, then I have been known, and my colleagues as well, to go ahead and enter an ex parte preliminary child protective order without it being screened by CPS first. But obviously everything is on a case-by-case basis.
Judge McHale?
Well, there's another dimension of this whole problem that we see sometimes, but sometimes I'm not sure everyone's completely attuned to it, and that is this judge talked about bypassing a process, but there's this parallel process about the criminal prosecution, people going to a prosecutor as well. And so you may find a situation where your client is subject to prosecution and has to as well defend himself or herself in the civil process, and you have to be really concerned about that, because these allegations of obviously sexual abuse or even physical abuse can involve a parallel criminal process, and there you are stuck in trying to defend for purposes of gaining your custody rights, but at the same time being concerned about the Fifth Amendment issues about implicating himself or herself. So just be concerned about that, and because if you have a vindictive spouse on the other side, or a person, whether even not they're vindictive, whether there's some merit to the claim, that's a real issue. And a lot of domestic lawyers are not criminal lawyers, and for good reason. They don't practice that, but they need to be attuned to that. And it puts you in a real box, because you want to basically win the case, but at the same time, you have to be concerned that there may be something else going on out there that you don't know about.
You said this had to do with rape, and said rape is a charge that's easy to make, hard to prove and even harder to defend. And I think child abuse allegations in the context of a custody case are problematic for me in a number of ways. I'm responsive to the fact somebody makes an allegation a child's been abused. I need to respond to that, so I'm going to err on the side of responding to it. And sometimes I think that does a disservice to the person that's been accused because, as you say, we say, okay, we're going to stop visitation, we're going to order counseling, all this stuff goes into place, and then what I find happens is the stretch goes on and on and on, maybe 8, 9, 10 months, a year later, the person that's been accused has had limited contact with the child, which affects his or her relationship with the child. Basically, you're telling the child, your daddy, your mommy's dangerous, which I think is significant. And then you start the process, if it's been resolved in his or her favor, of reuniting the child, which takes another 6 months or a year. And frankly, I've been doing this in both courts for 18 years, and I see such damage to children in the context of a custody case. And I see such damage. And I just had a young lady last week in criminal court that I had when I was a juvenile judge. And parents fighting. She's in front of me. She's 32. And I had her when she was 14. She has 5 children, none in her custody. She's a heroin addict. And I want to find her mother and father. And I'm going to be very unprofessional, take a 2x4 to both of them. Because they did it. They did it. And so and unfortunately now I'm seeing the product of that. So people make allegations. Maybe they're valid. I don't know. But I have to respond to it. And I just see that process that gets in place. And it disturbs me. And I don't know, how do you resolve it? How do you resolve it? I'm going to make a joke here. I don't mean to. I have a dog. You see I have a dog? Well, my dog, when I first got her, she goes to court with me every day. She goes up under the bench. She sits there. She's very good. Doesn't do anything. One day she barked. The guy came out of lockup. She started It sort of freaked me out, and the deputy's out, so we take her away, and she starts throwing herself against the door to get back in, and so I can't figure out what's wrong. And so I called her trainer, and the trainer says, well, she's a very intuitive dog, and she sensed either the guy didn't like you, or he was a very bad person. So I'm not kidding. So I thought, okay, this is cool, and so this happened 3 more times, and each time the person has been, I think they didn't like me, but they also were not nice people. So I'm thinking now, instead of just evaluating credibility, I'm just going to have my dog do it. So that will solve everything. But now, that's I'm being flippant here, but it's really, I have such fear that I want to make the right decision. It's like in protective order cases, special abuse, you want to make the right decision. You want to read about it in the paper in 2 weeks. And you want to read about the child being hurt further. So it's just, I think for all judges it's difficult. And for me, it really is.
Can I get a dog?
Sure.
It would make my criminal dockets a lot shorter.
Yeah. I'll give you my cane, too.
Okay.
It's a new spin on the sniff test.
I'm not having lunch. I throw the ball with her at lunchtime, and a group of lawyers come up to me like a mass, and they go, Judge, we want you to know if your dog growls at our client, we're asking you to recuse yourself. I'll do it. No problem. So.
Well, the problem with these allegations, too, we all know it is that if they're made, even if they're not made by the other spouse, the real difficulty, one of the difficulties you have is convincing the spouse, the other spouse, that it didn't occur. I mean, you can adjudicate it, okay, it's unfounded, you can say, I can't find there's sufficient evidence in court of law, but the problem is you're managing the other party who may sincerely believe that it happened. And that's one of the legacies, that you talked about. It just goes on and on and on because they firmly believe that it occurred, and nothing you're going to say is going to convince them. It's just, the system is biased. They hear the objections to hearsay, and they get frustrated by that, and they think that the system is just wrong, and that they're not being heard, and the child's not being heard.
Another problem is that you start telling the child it happened over and over again. And then eventually, as I think Dr. Stolberg mentioned, you can create memories. No, I'm not saying it happens all the time, but it happens. It does happen. And if you say it over and over again, then the child's going to start believing it. So it's so hard to ferret out the truth of these things, it really is.
Judge McCahill, you raised the question about sometimes there's potential criminal charges. How do you balance the rights of parents and the interests of the criminal justice system? For instance, discovery and access to maybe the DSS, the CPS records, the interview, the recorded interview, things of that nature. How do you balance those interests? You just put the custody case on hold, and then allow that negative consequence that may not be appropriate? I mean, how do you all handle that? What's a stumper?
I'm not sure there's one answer. I have seen situations where what is clearly, a member of the criminal bar come into the domestic case, and they're using the civil process to assist them, because they know there's going to be a criminal prosecution, assist them with the discovery that they can't get in the criminal case, to use the civil process to try to get some of this information. And I've seen that occur, and I have seen situations where people have asked to put cases on hold, and they will be subject to that interim order where they have to maybe have some supervised visitation otherwise till they can get this criminal process out of the way. Because sometimes there is a criminal process outstanding, and they have to deal with that. And they know that they don't want a final adjudication in a civil case where they have to remain mute and take the Fifth Amendment from having a binding adjudication until such time as they can be freed up to speak, so to speak.
Judges in Leesburg are so smart and articulate. I can't do anything with that.
One of the problems I've been having, actually for the last 11 years, is the protective order, and how that seems to bring into play all the issues at one time, where the wife will file a protective order against the husband, and she will seek custody and visitation of the children. She'll seek temporary support. She'll seek sole possession of the marital residence. As a result of the alleged offense in the protective order, there's a criminal offense or a criminal charge filed against the father. They seek possession of the vehicle, and it's just a mechanism for them to sort of expedite every possible thing that you could expedite. The criminal, the divorce side of it, equitable distribution, not all of equitable distribution, but obviously temporary possession of the home. And those become problematic for me, trying to decide. And the concern I have is the standard of the burden of proof on a case like that is so low, and yet the remedy is so extreme. And trying to determine if this is some type of vindictive action to gain an upper hand in future custody visitation hearings or support hearings, or in the criminal case itself. And I don't think there's really a single good answer. I think you just have to take those on a case-by-case basis, try to get to the bottom of it, trying to find out what the purpose is, what the motivation is. And certainly, for God's sake, I hope I don't make the wrong decision by granting significant relief to someone who's just blowing smoke and trying to get back at the other partner.
You have to make that decision in 30 minutes.
Oh, yeah, or less.
So, is there any universal view that you all may have with regard to the impact unilateral action by a parent using the child in the context of a custody case has on your determination? For example, where one parent unilaterally selects a counselor, takes the child to a therapist, allegedly because the problem is some problem that the other parent has with the child, but the alleged offending parent is totally in the dark about that. How do you view that? Do you view that as something that's appropriate behavior, inappropriate behavior whenever anyone's acting unilaterally?
You're describing some cases.
It's like this is like when you're at the Court of Appeals. You get those kind of things.
It's more fact-driven than that. People make a decision about counselor maybe because of inaction by the other spouse, and then what happens? The other spouse goes, they made a decision without me, and when we tried to get you to make a decision, but you didn't. So it's not that black and white. And but you do have some examples where, when a parent is just doing everything and blowing off one parent and making decisions about school, this and that would affect me. So you should involve the other parent. If you're not doing it, that's another thing you have to consider. Your willingness to create a relationship between parent and child. They're not doing it, so that's a factor I have to consider. But I think you have to have. It's not quite that simple.
I would say on its face it seems inappropriate, but then again, if you dig deeper, you may find that there was a good reason for that parent doing that.
So you're really looking at what the motivation is on the part of the parent, and if it is just to exclude the other parent, then that's going to count against.
Well, and just as it was said, there are situations where some people won't talk to the other side. I mean, you could consult all you want, but they're not going to talk to you. They refuse to talk to you. There's a lot of animosity. And so there may be justifications for it, but fact-driven, I agree.
In a lot of cases, we see courts generally giving joint legal custody. When you have that kind of situation where at least one of the parents is refusing to communicate with the other parent, do you instead give one party the sole authority to make those decisions?
What does joint legal custody mean? I'm asking, what does it mean?
According to the statute, it
Well,
allows both
what is
parents
it
to make-
practically? What does it mean?
It means I feel like it feels good because nobody took something away from me.
No, that's what it means. That's exactly what it means. But, and practically speaking, it doesn't mean. It's just it doesn't mean anything. Yeah, it doesn't mean anything.
It's what you had before you walked into court.
Yeah. But I hear it all the time. Well, that line case, mother let her little girl pierce her ear and her belly button, and the father objected to it, and that was the issue. Yeah. Well, the mother said he doesn't like piercing, so I didn't ask him. I thought, hey, maybe you should. Your daughter's put holes in her body at 14. Maybe you should. Different world.
The problem we always hear is cell phones. Cell phones is a big issue. In joint legal custody, one parent thinks the child ought to have a cell phone, the other parent doesn't. They're not going to agree on that, and I certainly sure as hell don't want to bring it to court because I don't want to hear it, and I don't want to make a decision as whether the child gets a cell phone or not. So bottom line is the parent who doesn't want the child to have a cell phone files a show cause and ends up dismissing it.
My observation on that point is that a lot of times I observe that there are a lot of intact marriages where mothers and fathers disagree on rules for their children, disagree on clothing decisions, disagree on discipline decisions. I mean, it's just a fact of life that people come at issues differently, and the divorce status is really no different, except that it's highlighted sometimes because they got to the divorce status. I see that issue coming up primarily in change and modifications, and interestingly, it seems to me the majority of cases I see that people often come to court and litigate, or they say, Judge, we agree to joint custody, but we disagree on visitation, physical custody, and then they spend 2 days telling you why they can't communicate, and I'm always scratching my head thinking, gee, and essentially, they've agreed to joint custody, but they've now spent 2 days saying why they don't speak and they have to use email or whatever, but notwithstanding that, where I see it come up is in these situations where following an adjudication, where they tried joint custody or they agreed upon it, maybe they didn't fully appreciate what it meant, that it has created gridlock. And that's where, dad is taking the child out of the soccer, putting him in taekwondo, and mom is taking it out of taekwondo, putting it in soccer, and they don't agree on the doctors, one goes to one, and it's just gotten to be absolute gridlock, where third parties are being absolutely frustrated, doctors, and that's where I think there has to be someone to step in and say there may have to be a tiebreaker here, and then people come in and say, well, we want a parent coordinator, which in essence is a delegation to a third party of the parental responsibility. So that's a whole different issue. But that's what I see happening a lot.
I was I was about to bring it up when you already did, Judge. The concept of parental coordination. I don't see any statutory authority for it, but I see lots of certainly mental health professionals that encourage it. But do you view parental coordination as something that helps the docket by eliminating these things coming before you, or do you view it as giving your authority to some non-legal entity?
I don't delegate. I don't think I should.
My big question is who's going to pay for it?
Well, obviously the parties would have to pay for it if they're going to do it, but
a lot of times we have a lot of things we'd like to do, but the state certainly isn't going to take on that financial responsibility, and the parents aren't able to afford it.
I see attorneys agreeing to it in agreements that are incorporated, but I have never done it because I think I shouldn't delegate the responsibility.
I think one of my functions, maybe you all disagree, I have a standard pitch I make in custody cases, and I tell folks, you're going to be with me for maybe 2 hours, maybe 4, for lucky 8, and I'm going to hear some evidence about you and your children, and you're going to ask me to make decisions about your children that are going to affect them for the rest of their lives. A total stranger. You and I don't know each other. You're never going to know each other, but you're asking a total stranger to do this. Do you want to do that? Because I'm not going to really, frankly, I'm not going to care if you don't get Mother's Day, Father's Day. I'm not care about that stuff. You need to care about that. And I don't know if it works out. Sometimes it does, sometimes it doesn't. But I think if I were to do a parent coordinator, I'm abdicating my responsibility. I'm giving them a pass, and I don't want to do that. I think they need to be parents. Step up and be parents. So.
Please write down the following code. The letter X as in X-ray. Audio codes are embedded randomly throughout this program. Please write these codes down in the order in which they occur. The code again is X, as in X-ray.
How do you handle, you said there are times that people have agreements where they provide for a parent coordinator, but then there's disagreement and it comes back to you again. How do you handle, if the parties have not well defined the role of the parenting coordinator, you just say, we're not going there, it doesn't matter what you all agreed to, you're back in my bailiwick, or how do you handle those things? So I've had that problem where something came back and the judge just said, there's no authority for this. I can't tell you what was in your mind, and I'm not going to go with it anymore. So, have any sense how you handle it?
I've been asked to do that. I've declined to do it. I think it's parents abdicating their responsibility, taking the easy way out. If they have one and they have a disagreement, I would say, I don't care about that. If you want me to start running the show, I'll do that. If you guys can't agree, forget the parent coordinator. It's just another level. It's another reason to come back to court on a show cause because you got a disagreement about soccer pickup drop-off time. I'll do it now. I don't want the parent coordinator. If that sounds abrupt, I'm sorry, but it's a way to get back in court for more litigation because you got another layer in there. It's like saying, counselor, you decide visitation for the children. What does that mean? And they're not going to agree with the counselor's decision. It's just come on back to court. Let's keep coming back to court to work on that. So making them be parents. So,
you mentioned it being in a consent order. Obviously we are not under any obligation whatsoever to just sign off on consent orders just because parties have agreed. I'm not exactly sure how all my colleagues do it, but I review every single consent order that comes across my desk, line by line. And if there's things in there that I have a problem with, I won't sign it. I'll contact counsel or I'll contact the parties and have them come in and say this isn't going to work. So I think a lot of lawyers perhaps get the impression that if it's by consent that we're just going to rubber stamp it, but that's not the case, and it shouldn't be the case.
I just reviewed the orders to make sure I didn't get custody in the orders. That's what I worry about.
That's not for college expenses.
If you get custody, do you also get the support? No,
yeah,
I'm just wondering.
believe me.
A lot of people ask questions along the lines of using children as witnesses in a custody case. So what I'd like to know first, do you all have any sort of policy or general procedure that you follow, criteria for hearing from a child or not hearing from the child? Then we'll tackle the question about how you handle that. But is there any kind of bright line that you all have? And if you do you let people know that so that they don't suddenly bring kids out of school and have them sitting in the hallway only to find out you're not going to talk to them anyway?
I look at it two ways. Children are invested in this process too, and sometimes they feel disenfranchised if they haven't spoken to somebody, and they know there's a guy or a woman in a black robe that's going to make a decision about them. Now, sometimes I think I should talk to them merely to know that they know they've been heard. And I always tell them when I talk to them,